All right, so thank you everybody for staying with us through the afternoon. My name is Matt Lisiecki. I am a senior research and policy analyst here at the Center for Migration Studies, and I'll be facilitating today's discussion on the weakening of the U.S. protection regime and the impacts on human rights. The last 10 months have seen seismic changes in U.S. immigration policies. Well, much of the news understandably focuses on the horrifying and indiscriminate expansion of raids and detention targeting those with vulnerable immigration statuses. There has been relatively less discussion of the creation of many more vulnerable individuals thanks to the intentional dismantling of our systems of protection pathways, including halting refugee resettlement, creating barriers to new asylum claims, cancellation of temporary protected status and humanitarian parole, not to mention the slashing of funding to organizations providing legal, resettlement, and other key support to vulnerable populations. Together, these developments have stranded those looking to flee hardship and increased the vulnerability of millions already in the US. I'm joined today by four esteemed panelists to update us on recent changes to the US protection regime, share stories of the human impact of said changes, and discuss methods of response. I'll just quickly go through and introduce everybody, and you can refer to the speaker bios in your folders for everyone's full and esteemed biographies. But I'm joined from, I guess, my left, your right, on down, by William Canny, Executive Director of the Migration and Refugee Services at the U.S. Conference of Catholic Bishops, Anna Gallagher, Executive Director of Catholic Legal Immigration Network, Inc., or Clinic, Dorothea, former Special Counsel at the USCIS Refugee and Asylum Law Division, and Kelly Agnew-Barajas, Co-Director of Immigrant and Refugee Services at Catholic Charities of New York. Thank you to everybody. Bill, we'll start with you. What have been the policy and human rights impacts of recent changes to the U.S. refugee resettlement system?
Well, thank you, and it's a pleasure to be here, folks. Let me take you back a little bit to the roots of refugee resettlement in the United States. Rooted in a history primarily from religious persecution, the United States boasts a long record of welcoming refugees, as you know, from across the globe. The Catholics, as well as other faith-based and secular organizations, began resettlement-like programs over 100 years ago after World War I. In 1948, after World War II, when the reception of refugees was almost entirely undertaken by faith-based groups, 105 of the 119 Catholic dioceses in the United States at that time had a resettlement director appointed by a local bishop. Since 1977, which marks the start of this era of refugee resettlement, the U.S. has resettled more than 3.6 million refugees who have largely successfully integrated and meaningfully contribute to the fabric of our country. The United States has adopted the legal definition of a refugee in accordance with the 1951 Refugee Convention, which includes people who flee their country based on well-founded fear of persecution, race, religion, nationality, membership in a particular social group, or political chosen related to some form of political persecution. To its credit, from my opinion, and it can be debated, the refugee chosen by the U.S. government has never been assessed for what he or she may contribute to our country. We do not assess refugees to what they may contribute. Certainly some political calculus has gone into groups of refugees chosen, but the individual selection has adhered to by the definition and has largely been a purely humanitarian exercise. In 1980, in response to the aftermath of the Vietnam War, Congress passed the Refugee Act of 1980, which created a formal and consistent process. As you all know, post the claim during the first Trump administration that refugees were poorly vetted and dangerous, a formal analysis concluded that they were in fact the most vetted of all categories of newcomers in the U.S. Once a refugee individual or family arrives to the United States, they receive social services, limited financial assistance from a community-based refugee resettlement agency. There are a couple here through a State Department program called Refugee Reception and Replacement. R&P staff members are required to to provide several core services to the new refugees. Every year, the United States has the power to set the maximum number of refugees admitted during the federal fiscal year. Although the President must consult with Congress regarding this decision, the presidential determination ultimately does not need to be approved by Congress or any other party, meaning that the number of refugees admitted to the United States may fluctuate every year based on the administration. The average number since 1980 is 85,000 per year, resettled in almost all 50 states. After President Trump took office in January 25, he announced a series of executive actions, including one that indefinitely suspended refugee arrivals. On January 22nd, the day the ban went into effect, about 32,000 refugees had arrived in the U.S. since the beginning of the fiscal year, and previously scheduled travel was canceled for over 22,000 refugees who had already passed all security screenings and had their flights booked. Approximately 1 month later, on February 26th, the U.S. Department of State terminated cooperative agreements with all 10 national resettlement agencies, of which we were one, providing R&P services. The executive orders were telling in a few ways. One, only refugees who could fully and appropriately assimilate could come in the future. So we're making a judgment on their ability to integrate or assimilate. State and local jurisdictions should be granted a role in the process, and a proposal would be developed to promote such involvement. Refugees could be allowed in on a case-by-case basis if it was determined in the national interest and they do not pose a threat, and within 90 days and every 90 days after a report, after his executive order, a report would be submitted to the president until such time as he restarted the program. Due to the halt to refugee arrivals and the non-payment of monies for work already done by resettlement agencies, our own agency sued the government for payment and for the obligation to complete the 90-day program for refugees who are already arrived in the country. Another lawsuit named Pasito was filed on February 10th by our friends at IRAP and a couple of other agencies on behalf of some refugees. The agencies, and by extension refugees, got whiplash during the next month or so as the government suspended, terminated, intended to reinstate, reinstated, and suspended grants with the agencies. Eventually, 2 agencies quit, ourselves and the Episcopal Migration Ministries, and grants for the other 8 were eventually extended until today for a quarter until the end of this calendar year with certain restrictions. The Pasito lawsuit, as I mentioned by IRAP, representing a group of individual plaintiffs and several resettlement agencies, provided some early hope that injunctions would prevail. But following oral argument before the Ninth Circuit Court of Appeals on September 3rd, the Ninth Circuit...
Can you use the speaker mic?
Oh, yeah.
It's not on.
Oh, you want to hear?
Oh, I'm sorry.
There.
Should I speak louder?
Here, you can.
The Ninth Circuit panel of judges issued an initial order on September 12th, which almost entirely vacated the district court's prior preliminary injunctions. As a result of this decision by the Ninth Circuit, the government is no longer subject to any court order requiring it to process or resettle additional refugees. The case is now at the district court for further proceedings. For the record, the resettlement agencies have been reimbursed for previous resettlement activities for those who are already here, including ourselves, but as you know, the program remains halted. There was an exception made for the arrival of approximately 70 Afrikaners last summer, thus the results of the separation of the program to date.
Thanks, Bill. Sobering news. You mentioned, just a quick follow-up question, you mentioned 22,000 folks who were all approved, all ready to go, flights booked. Can you talk a little bit about what's happened to those folks?
Well, they're still basically overseas. A lot of them would have lost their medical clearances and security clearances now. This is the tragedy But as you know, the presidential determination has been made at 7,500 Afrikaners. It was put into the registry recently. They also need to consult the Congress, and my understanding is that the administration has written a note to Congress initiating a consultation process for 7,500 Afrikaners. The two-paragraph statement is in comparison to a 60-page statement that the administration gave to Congress last year to begin the consultations. PRM in State Department has been gutted, excuse me. You'll remember they were actually all told to leave the building one day in the summer. PRM looks like it will keep overseas processing, along perhaps with some non-governmental organizations, to process folks coming in. Right now it's 7,500 Afrikaners. It appears domestic resettlement will go to the Office of Refugee Resettlement in HHS in a program that may be labeled Program for Initial Resettlement, PIR. We have never seen any of the 90-day reports that were reportedly done. We know that some state refugee coordinators were surveyed. You remember I mentioned it was going to go move perhaps to states. Some state refugee coordinators were surveyed by an independent entity about state involvement, and a report was developed. Questions remain. What will the role of resettlement agencies be after December 30th? All do have a relationship with ORR, fortunately, and a program within which the PIR, as I mentioned, could be nestled initially. How will the role of states evolve? The report talked about aligning local and state needs with education and skill sets of potential refugees. So we may see a move from a purely humanitarian program to something akin to what we see in other programs. How will the refugee benefit a local, state, or national community? This will change the nature, of course, of the program. So for me and others, we're left with the greatest, what I think was private-public partnership. So many of us have participated in over 25 years for myself and 45 years for others. I think will never be the same. Thank you.
Thank you. And yeah, the changes, the disruption, the dismantling are truly staggering. As I think you mentioned as in a question one of the earlier panels, Bill, refugee admissions, because of the caps, have only ever been a fairly small percentage of folks arriving in the U.S. and the various immigration statuses available to them. So I think, Anna, I'll turn now to you to hear a little bit, maybe about some of the unintended consequences that Moose mentioned earlier, some of the humanitarian pathways that folks have been using, the changes that we've seen in those pathways over the last over this calendar year, and how the Immigration Legal Services system is handling that.
Thank you, Matt. Can everyone hear me? Yeah? Oh, okay, great. Well, it's a real pleasure to be here. So I'm tasked with talking about what are the most significant changes in the immigration legal system that we're seeing. So we are now in a system defined by instability. The immigration legal landscape is shifting faster than families and legal providers can keep up with. The frequent policy reversals, the rapid rule changes, and litigation-driven swings make it nearly impossible for people to plan their lives and produce chronic uncertainty that fuels fear in immigrant communities, and we've certainly all seen that. We call it the rug-pulling strategy, where the very ground on which we stand on as legal service providers now feels suddenly unstable. I'd like to talk about what this looks like in terms of three major areas: threats to humanitarian pathways, lack of access to immigration legal counsel, and finally, increases in immigration detention. So, threats to humanitarian pathways. These were programs designed to protect and provide safety for the most vulnerable immigrants coming to the United States. And they include things like temporary protected status, TPS, asylum, and humanitarian parole. These programs are increasingly fragile or being abruptly dismantled. Temporary protected status, TPS, is meant to provide protection for immigrants already in the United States who are unable to safely return to their countries during war, natural disaster, etc. We're seeing these programs suddenly dismantled, terminated, including for some of the most conflict and disaster-ridden places in the world, such as Afghanistan, Haiti, Sudan, and Ukraine. So, short down-wind periods and unclear transition guidance for TPS have caused chaos, forcing families into crisis with no meaningful alternatives to remain in the United States. And many have lived here for decades. The same can be said for humanitarian parole programs, which were temporary programs extended to certain categories of immigrants seeking safety. Many have been suddenly terminated. These people came here under a legal process within the last few years, came under a legal process, and are now being treated as though they didn't. They are very vulnerable to the current enforcement push. So in terms of asylum, we are seeing deeply concerning trends on top of restrictions on access to asylum that we had already been seeing under the Biden administration. These include wealth testing by imposing fees. There is now a fee to apply for asylum in the United States, which we have never, ever seen before. We're seeing adjudicators being constrained and having their discretion narrowed, allowing for immediate pretermission or dismissal of asylum applications without a full hearing before the immigration courts. Use of pretermission means that immigrants' cases are being dismissed without full adjudication, and this is leading to ICE arrests at courthouses and in other places of people who have been in the legal process seeking asylum, and many for many years. So now turning to barriers to accessing legal counsel, and this is something that Clinic sees often. We're an affiliate network with over 400 affiliates across the country, so we're hearing about this daily. Obtaining legal assistance is the difference between navigating the complexity of the system or falling through the cracks. In many cases, it's the difference between life and death. Yet the highest need communities still face the greatest obstacles of finding representation. We have long had a shortage of affordable immigration legal assistance. A CMS study from several years ago said that there was approximately only one immigration legal service provider for every 1,400 immigrants. One. But now this issue is even worse. Nonprofits can't meet the volume of urgent and complex requests. They are completely overwhelmed. We're also seeing attacks on our capacity via funding cuts and due to threats against us, including threats of investigation and sanctions for providing immigration legal services. This has caused a chilling effect across the field. As detention of immigrants has increased, we're also seeing immigrants move to remote facilities, transferred between them, and other factors that make representation difficult even when counsel is available. The reinterpretation of detention policies pushes detainees into federal court to seek release, and not all attorneys are able to practice in federal court. So we know that outcomes depend significantly and dramatically depending on representation. So I'll share a couple of statistics. Among people facing deportation in immigration court, 44% have no attorney. 44% have no attorney to advise them of their rights, advocate for their release from detention, or help them exercise their rights in their deportation cases. I recall there was a footnote in the Supreme Court likening a Supreme Court decision likening immigration law to the complexity of tax law. 44%, folks, do not have legal representation. Of the more than 450,000 people who were ordered removed in immigration court over the past 12 months, 75% lacked legal representation. 66% of children, of kids facing deportation in the last year had no legal representation. The nonprofits across the clinic network and across the country are scrambling to find the resources and get the training they need to meet this moment, but it is an enormously uphill battle. So let's talk a little bit about expanded detention. So expanded ICE enforcement, unpredictable arrest, and remote or hard-to-access detention facilities deepen the fear in the community. Even people with strong legal claims, TPS holders, asylum seekers, special immigrant juvenile youth, and with permission to remain in the country are being detained and pressured into self-deportation. There are currently close to 60,000 immigrants being held in ICE detention. Now, there were 39,000 detainees in ICE custody when Trump returned to the White House in January 2025, a number that rose to 61,000 in late August and could reach as high as 107,000 by the end of the year. No prior administration has had an average of more than 50,200 people per day in immigration detention. It's important to note that most of the people being detained are not criminals, and many have a lawful right to be here. Please remember that. Please remember that. Some have deferred action, others have pending cases in immigration court. The administration, this administration, seems to believe being an immigrant out in society itself is a threat to public safety. So their reaction is to detain as much as possible. Immigration judges' authorities to release immigrants on bond have been restricted, so people are held indefinitely in deportation until they can be removed. Detainees who can no longer seek bond through the immigration court now have to seek relief through federal courts in a habeas petition. Many detainees do not do that, and they choose to self-deport because they cannot remain in detention for years. So that's the updates, Matt. Sorry, folks.
Thank you for sharing. Should have mentioned before we got started, this was going to be the heavy panel. So I thank our panelists for kind of sitting in that knowledge. Anna, a follow-up question for you. If you could share a little bit about what immigration legal service providers are doing in response to some of these challenges.
Good. Yeah, and this is a wee bit of good news, okay? And I just want to start before I say that. So the immigration legal service providers across the country are the angels. They are working so hard. There's Catholic Charity folks here, too, representatives of Charities, affiliate members here. You are, can you raise your hands? There, we got them. So we got people here who know what's happening on the ground, right? So we have amazing people across the country that are working double, right? They are dedicated to our immigrant brothers and sisters. So that was bad news. But I will say, hope does not disappoint. And that's what Pope Francis has said. And that's what I feel now more and more than the past administration, to tell you the truth. I think people know the stakes now, and they're ready, and they're standing with our immigrant brothers and sisters. So that was the good news. I'm just going to answer your question quickly now. Sorry. So what are the legal services providers doing to respond to these challenges? So leveraging networks to share information. Everything is changing really rapidly, right? So we're seeing a lot of cooperation and coordination under the field. Under Trump 1, we didn't have as many networks. However, we worked hard during Trump 1 to create networks. So now we have networks such as the Ready State Coalition, and there's other coalitions that have resources that share more broadly. So we've expanded. So that's a positive. So we also, as smart legal providers, are helping our clients to develop strong records of appeal. So when we go into court, the opportunity to respond is being pushed from immigration courts into federal courts, and we are making the records, right? We are smart people, and we're making the records to convince federal court judges this is wrong. And we see the federal court judges pushing back. So that's really promising. So gaining capacity for habeas cases. Many immigration attorneys have not practiced before federal courts before. Now that the cases are being pushed from immigration courts into federal courts as habeas corpus cases, there's a mass movement to try and get attorneys trained up and trained up across the country to take these cases. So my own staff, there's several members of my own staff that are taking pro bono habeas so that they can train, because that's what we do. We have to know it first before we train. And then continuing to build capacity as much as possible. We still have critical projects trying to build legal services capacity across the country. We're helping organizations to hire and train new staff and keep their doors open. There are also new organizations opening their doors even in these tough times, so we're hopeful. So one primary way we continue to build capacity is through the Department of Justice Accreditation and Recognition Program. Many people don't even know this exists, and I will admit, when I started a clinic, I didn't know about them. That is a glaring shame. However, this is a program from the federal government that gives credentials to certain recognized nonprofits to allow non-attorney staff members to provide immigration legal services to immigrants. And of course, that's after rigorous training and mentorship. Clinic is at the forefront of training these people, known as accredited reps. And it is critical way, and this is a critical way for organizations to hire people, legal staff at a lower cost. Attorneys cost money. We're expensive, right? And accredited reps do great work, and they can represent people. I want to just finally read something about Catholic social teaching really quickly, Matt.
Please.
Thank you. Okay, so I always include this in all my presentations, and it grounds me, and I feel like it's a superpower, these 3 points, and I'm going to share them with you. So Catholic social teaching on migration states the following. People have the right to migrate to sustain their lives and the lives of their families. Right? Nations also have the right to control immigration and their borders. And I appreciated Moose's presentation. They have a right to control immigration and their borders. 3, nations have the responsibility to manage immigrants and immigration with justice, mercy, and respect for human dignity. The third principle is central to understanding and balancing the first 2. The Church teaches that human dignity and the Christian mission toward charity and mercy must be paramount. Catholic social teaching recognizes that uncontrolled migration can undermine the common good. And also that control of migration without justice and mercy often amounts to cruelty and to violating our deepest values as Christians. And I'll finish on that. Thank you.
Thanks, Anna. And briefly on the point of DOJ accredited representatives, if you'll allow me to briefly commit the sin of self-promotion, look for an upcoming report from CMS and our partners at Villanova University going very deep in depth into the RNA program nationwide. So turning to you, Thea, having heard from Bill and Anna where we are now, the simple question with a complicated answer of how did we get here?
Yeah. Well, maybe a little tiny piece of how we got here.
Sure.
Anyway, yeah, these were really, I don't want to say I guess I appreciated the kind of grim summaries, but it makes me think really back to, though, having worked on refugee and asylum issues in government for 32 years. Yeah.
Closer to your...
Oh, sorry. So having worked in government for about 32 years on refugee and is this one working?
It's on.
It's on? Okay. Hold it closer. Okay. And then, in refugee resettlement, I was involved for about 10 years before that. And it just, I think, like so many of us, we remember that traditionally there was sort of this bipartisan and broad public support for these programs. And is that?
If that's easier.
Okay.
Yeah. It's on.
It's on? Okay. All right. Is it on now?
Yes.
Okay. And it just seems like that has eroded under this like the discussions earlier today about these anti-immigrant sort of narratives, casting asylum seekers as fraudsters and criminals, or at least just people who don't either deserve or warrant or even need protection, and asylum itself and refugee protections as loopholes that are to be, they're just part of an enforcement system. They're loopholes in an enforcement system. Like how we sort of address those narratives. I think we've talked about that a lot today, and there are certainly, what created the ground, like the fertile ground for these narratives to land within the system? Like, we thought it would make sense to spend a little time talking about some of the structural and institutional, like, features of the system that may have contributed to there being this fertile ground for those narratives. And I think if we do that, we have to kind of acknowledge that the asylum system hasn't been working for a while. We've all talked about the crushing backlogs, both at EOIR and the immigration courts and at USCIS. Towards the end of the Biden administration, USCIS, my agency that I worked for, was so overwhelmed by border processing that it wasn't really processing any affirmative cases at all. All the resources were going to the border. So there have been a lot of good ideas that people are talking about in the field, and I really appreciate, seeing those being discussed about, restructuring EOIR and the immigration courts to give them the resources and independence to, be able to deliver due process and to be able to deliver reasoned decision-making. Also, effective protection mechanisms at the border. But whatever you think about those, how we restructure processes, I kind of wanted to talk about what I think is a deeper and sort of long-standing confusion about eligibility standards themselves, and how confused and overly complex those standards have become, and why that is. Like, why in this area of law in particular has it become, as Anna was saying, like, as complex as tax law, which, is obviously involves a constituency that, has American taxpayer dollars and is going to be really well funded and really well represented. And, why has this area of law become so complex? And also how that complexity has played a role in really kneecapping the system's ability to handle its caseload, and also has undermined support for the system as a whole and for the concept of asylum as a whole. I really do think that that confused standards and opaque standards and inconsistent outcomes, which we see increasingly, have fed skepticism about the legitimacy of asylum and the need for an asylum system among policymakers of all stripes and also in the public. I think like the statutory core of asylum and withholding, persecution on account of race, religion, nationality, membership in a particular social group, or political opinion, that was never meant to be as complex as it has become. And today, I think the problem is that we don't have sort of a uniform interpretive system. Rather, eligibility standards are governed by this increasingly incoherent and inconsistent web of case law across different jurisdictions that have all taken different approaches to different issues. And I do think that as I've seen these standards develop, the people who suffer the most among the the vulnerable population of asylum seekers is the most vulnerable. It's like those cases that are based on the realities of modern day persecution, often involving women fleeing domestic violence, or children, fleeing gangs that are seeking retribution on somebody in their family. The standards that govern those kinds of cases that are set out in this web of case law are so full of tension and inconsistencies and even contradictions about what the different elements of the eligibility standard mean and how they apply to modern day persecution, that you just can't get any kind of predictability in decision making. Like, what is a particular social group? What is persecution? How do you decide if a state is unwilling or unable to protect an applicant from non-state persecution? I think these kinds of questions, because the elements all work together in an adjudication, really require a comprehensive analytical framework that, in the first instance, rather than sort of piecemeal interpretation in the context of reviewing courts looking, at an existing decision, that kind of piecemeal interpretation has just not provided us with any kind of comprehensive analytical framework. We could have done that, and there were efforts to do that through regulation. Regulations could, start at the outset and lay everything out and say how you analyze, how adjudicators should gather facts and analyze cases, but we've never been able to publish regs like that. We started, the first attempt, I think, was in 2000 with the so-called 2000 PSG rule. I personally have been involved in 5 different attempts internally to try to regulate. We never pushed it over the finish line. Even when we had an executive order at the beginning of the Biden administration instructing us to publish regulations to clarify standards, we worked on a regulatory package, but we're not able to push it over the finish line. I think people got distracted by border control issues sort of took priority. So with the executive branch essentially abdicating responsibility to, set out a clear administrative interpretation, it's just been left to these wildly inconsistent federal court and administrative decisions from the board that often sort of conflate the analytical elements and are really sometimes very hard to reconcile, if not impossible to reconcile, even with each other. I think a great example of that is anybody who follows PSG law is familiar with the chronic problems in applying the board's requirements that a particular social group be defined with social distinction and particularity, right? I see you're nodding. It's like what does that mean for a group to be socially distinct? Nobody knows because different decisions describe it in different ways. How would someone ever prove that? What evidence are you supposed to put forward? What makes a group discrete or viewed as a group? And is that part of social distinction or particularity, by the way? Nobody knows. It's just in practice, these concepts are really in the eye of the beholder, and they end up I've seen them end up operating as sort of get-out-of-jail-free cards to deny a case without having to, articulate any reasoned analysis. And then you just have this, that's on the administrative level, and then you have this motley assortment of federal court commentary, either, contorting themselves to uphold the decision or even when they're good cases, like you're saying, you build a record, you get a federal court making a good decision, they make them on all different bases, and they're even that doesn't really help clarify the law in a way that a first-line adjudicator can make a prompt and reasoned decision. So I actually think we should think about the structural barriers within how asylum law precedent is generated. And the fact that it's built on an appellate system that skews towards denials. Because if you think about, most of our guidance about what the law means comes from federal court decisions reviewing a board decision. And the government, DHS, cannot appeal an administrative grant of asylum. They can only, only an applicant can appeal a board decision. So that means that every decision that goes to the federal courts that results in precedent starts with an administrative denial that was based on a record that was built to support a denial. And then in federal court, the question is never, should this person be granted asylum? It's, is there a way to uphold this board's denial? So it's a different question than when you're starting out as a first-line adjudicator and saying, should this case be granted? And then you have DOJ, Office of Immigration Litigation, that views their mission as going into court and defending the board, because the board is their client. Can they defend this decision? It's not, is it the right decision? Is it, can it be defended? So, and then administrative precedent from the board. Well, the board's I think, years of politically motivated firing and hiring and interference with the board's operation has just sort of, really hampered its ability to deliver due process and to conduct reasoned decision-making or even to conduct, actual fact-to-law analysis. So the board decisions, I think, are pretty sparse and pretty uneven, usually also coming from an initial immigration judge denial where the record was built to support a denial. And where ICE is going into before the board with far more resources than an applicant usually has. So I think the whole reliance on appellate correction rather than front-end clarity has produced this sort of inconsistent and really mind-numbingly complex jurisprudence that's really designed to determine when a rejection can be upheld rather than telling adjudicators how to conduct an adjudication and how to decide promptly. As people have said, this critical to having a system that people can trust is that you can make prompt decisions. Well, I know from advising the USCIS programs that these social distinction and particularity inquiries take forever, and they're impossible to do consistently. So this kind of complex and confused and I think inconsistent standards, they result in more difficult, more time-consuming adjudications. So they exacerbate agency inefficiencies and backlogs. I know there was a 2017 GAO report that even identified in the EOIR context increasing legal complexity is contributing to the backlogs. And then, these inconsistent and unpredictable outcomes really undermine trust. If you have one decision maker who will grant a woman fleeing domestic violence asylum and then another one who will deny on such similar grounds, that really erodes confidence. The system looks capricious. And policymakers interpret inconsistency often as evidence of fraud and abuse, when it maybe isn't necessarily that. Although, honestly, ambiguous and vague standards are exactly what make the system more susceptible to actual fraud and abuse. And then, this is what I think is a big contributor to the system, being viewed as illegitimate, or the need for asylum being sort of not recognized anymore, and then you lose this sort of moral and political capital to maintain it. So I really think that something we don't talk enough about, we talk about clear and protection-oriented eligibility standards in terms of fairness for individual cases, and of course that's critical, but I think it's also critical to have a functioning system in itself and to have a system that people can trust in. And that's, it's really a false choice, this idea of order at the border and order in the system versus clear, robust, protection-oriented standards. I think the one is necessary for the other, and that maybe that's a piece of it that we need to talk about as much as we talk about, independence in the IJ immigration courts and systems at the border. So I'll leave it at that.
Thank you, Thea. Can I ask you to share a few thoughts on how we can think about the process of establishing those fair, uniform, protection-oriented standards?
Having worked on regs, over and over and over again that we were never able to do, I think that would be a critical thing to do. I'd love to do statutory reforms, but I don't have a lot of hope in that in the near future. But I think a reg, I think we talked, there's a lot of talk and good thinking about, protection at the processes at the border, like the 2022 asylum processing rule that would have allowed asylum officers to quickly and promptly resolve cases at the border when they were grantable. I think that could have been part of a solution, but we never fully implemented it or resourced it. Adequately resourcing the immigration courts and restructuring so that they have independence to do the jobs that they need to do. But I actually think we should think creatively about some less obvious barriers to fairness and efficiency too, coming out of this adversarial process versus the non-adversarial process, and maybe think about how the different nature of a non-adversarial process might be leveraged. And to explain what I mean by that, a non-adversarial program has a really different nature than the immigration courts with, that were designed to have independent immigration judges deciding relief as a defense from removal in adversarial proceedings where they're hearing arguments from opposing parties. Like a non-adversarial program that has specialized officers who are trained in, limited issues of protection, expertise, and are centrally managed across the country. They have a really different incentive and even ability to pursue consistency. So like our USCIS training materials would synthesize the case law and come up with a framework for analysis that we trained all of our officers in. And we could, I've thought recently about why we could explore, could you have some kind of mechanism where you could generate precedent out of grants, out of initial administrative grants that are on records in processes that are non-adversarial and don't come out of this litigation context where you have, the entire force of the government arguing against asylum. And I think precedent decisions, maybe you could have them certified to the AG or something. You could have some kind of system where you could have precedent being developed in a non-adversarial context. Maybe we could consider universal jurisdiction over protection claims in a non-adversarial process. I know that's been discussed before, but I think it could prevent bad law from being made. I can't tell you how many times I've reviewed cases. One of the functions that I was involved in for over 30 years was looking at federal court decisions that were adverse to the government. In other words, the government lost in the first instance defending the board's decision and deciding whether we should challenge those or whether we should, let them be. And when I look at the records in those cases, the initial decision makers, I would think, if I could just talk to if I were advising an asylum officer, I would say, yeah, you could grant on this basis, or ask these 3 other questions and you could probably grant. But once you get to the point where the whole decision is about whether you can defend an existing administrative decision, you've often already lost it. So if you could prevent those kinds of cases from getting to that stage to begin with, maybe that would be something you could do in the system. No, I think we should think creatively about using different parts of the system in different ways to try to maybe ameliorate some of the skew towards unfairness and complexity.
No, thank you for, again, incredible answers to 2 very short in words but complex in concept questions. So what we've heard from Bill, Anna, and Thea so far has been fairly high level, focusing on questions at the national and global levels. Kelly, for you, I'll ask you to zoom in a little bit to the local level here in New York City. How have these recent developments of the last 10 months and change impacted things at the local level?
Thank you so much for having me. And all these previous remarks were so interesting, and they all flow down to the local level, right?
Yep.
This is, I'm going to attempt to talk a little bit about what we've been through this past year, and I'll just highlight my fellow co-director, Margaret, because we do everything together. So we've been through this year together, and it's been an especially rough one. It's been, I think, even to talk about this year, in a sense, maybe it helps me personally to process what we've been through, to go a little further back, as you did, to thinking about the layers of what we've been through. In the morning, it was brought up, some of the response to the Syrian crisis. That's, for me, when things really started to be more seen, kind of as Justin was saying in the morning, I miss when we were flying under the radar, and at the time, I think I thought, oh, we need more attention. We're doing such great work. Even, kind of that struggle period after 9/11, we thought, oh, what is going to happen? But then things kind of resumed, and it had a natural cadence. Whereas I think the past 10 years, it's been nothing but relentless. So with the lead up to the first Trump presidency, we were being encouraged by our national partners, USCCB, it was Bill's predecessor at the time, to expand, right? Expand capacity, open more offices, get ready for Hillary Clinton to be president and for the resettlement system to kind of really take off. So we did that. And then really Trump, in the first term for me was more, the style was death by a thousand cuts. And that just seemed, very tiring at the time. Of course, the trauma that we've all went through with family separation, layered with COVID. When Biden came into office, really it maintained the pace of relentlessness, at least from my perspective, of like the Afghan response, the evacuation, gearing back up, getting everything ready to go from 0 to 100 in a week. In particular, in New York City, the Ukrainian response, right? This is the biggest Ukrainian community in the country, kind of, okay, we have to receive tens of thousands of people, very, very quickly, and kind of just layered on top of that, the asylum seekers arriving, about 220,000 folks that came to New York City and kind of with these meager resources. So we've been through a lot. This second Trump term has been, did not disappoint in terms of trauma inflicted to us or to clients. So, New York City is a hub of welcome, but it's also not the easiest place. I have told many, someone on a bus calling me, coming up from the border, like, I'm coming to New York, get ready for me. I was like, maybe do you have any friends anywhere else in the entire country? Because we don't have housing available for you. It's very tough. You really have to come here with a hustle attitude. And so if you're bound and determined to come, you should come, but it's very difficult to survive in New York City. Again, we've had extreme diversity of just our practitioners here on the ground. I think at one point during the asylum seekers crisis, we were spending an average of $40,000 a month just on interpretation. $40,000. And we don't have budgets. None of our budgets had a line like that for interpretation costs, right? So it's like we have to do what we have to do because that is the right way to serve people, but we don't have the resources that are really there to do what is required. We're also really blessed here to have a wonderful community of legal service providers, nonprofits, faith groups, mutual aid, NYIC, all of the different advocates, our college partners, our university partners. But even with that, there's just not enough capacity to do kind of enough that needs to get done for the folks that have arrived. And we're dealing with the lack of capacity that Anna pointed out of like, you can hire another attorney and in 3 months, that person has a full caseload. So we have to think much bigger about the right way to respond. The biggest thing we've been really managing day in and day out this past year has been the extreme volatility with funding, with rapid fire changes, just getting a letter out of the blue saying, this program's over, that program's over. So just trying to manage that for staff, for ourselves, for clients, for our staff who also have, various immigration statuses. So it's rising demand at the same time as just unpredictable resources that are making it so hard to plan, for the rest of the day, for the rest of the week, for the rest of the month, kind of what will even happen down the road. It's hard to think beyond like a short period of time because you're not really sure what to predict. So as I mentioned, we've had our own staff, our own colleagues, we don't know what status they have unless they've shared, by their own choice to share. But we have thus learned, people who had TPS and after working for decades, helping like tens of thousands, I would not, want to overstate, but literally like thousands of people to regularize their own status, reunify families, naturalize, had to leave because their TPS ended. I mean, it's really heartbreaking. So much fear of our own staff, people with pending asylum, that we thought, you have not a guarantee, but just this assurance that, you have your work permit, you've submitted your application, you're from Afghanistan, X, Y, like, you should be okay, right? Like, in the framework of what we understood. And, just watching these designations be rescinded, paroles expired, people falling out of status because that's what the policy is now, is to take people out of status rather than help people to regularize in some way. So that has been particularly hard to see, and there's so much institutional costs. Obviously the chief thing is worrying about the person who they have to uproot their life, lose their livelihood, return back to a country they haven't been to in decades, and make some sort of other life plan. But for us also, we lost someone, or multiple people who were trained, multilingual, working in the community, like they're doing the work every single day, and that is a loss for us as an agency. So the fear, you all know this, I don't need to restate the amount of fear, but one anecdote that I'll just pass on because it was particularly startling. I was talking with the emergency room. She has another job, but she also does rounds at Elmhurst Hospital in the emergency department, and she had a gentleman who did not seek treatment for a stab wound for 2 days. And, she was like, it was, in fact, just like the detail of kind of how startling it is that, the stories are really real, that people are not seeking medical care. They're afraid to, open their businesses and their kids. And, New York, we've not seen the brunt of it, and we're very concerned about what might come next. It's really gruesome to see how fear impacts our communities. So, this is very damaging, and of course, we thought, it was going to take the Biden administration and beyond to kind of repair Trump 1, but this is way worse than I think anybody was expecting, just to speak for all of us maybe. But, we're trying to think positively in a framework sense of what could come next that would be truly transformative, maybe really change things so that we can have more protections in these areas rather than these little Band-Aids that don't hold. They don't hold going forward. So I'll just kind of quickly go through some. It's not even an exhaustive list, but some of the programs that have been cut. Of course, all of our federal funding, essentially, all of our federal funding has been cut. So even our naturalization programs to help naturalize and expand capacity and help people to become citizens, we received the standard letter. I think it's just a form letter that says this program no longer aligns with the goals of the administration. So these kind of controversial programs that we would think, hey, anyone can get behind that. We're helping, civics and helping people kind of get right once and for all, but that was taken away. Bill already talked about the USCCB's withdrawal from the cooperative agreements, which, for us, decimated our resettlement programs, cut them, in a sense, by half. We understand the decision, but it's also very sad. And, a piece of the work is luckily picked up by another national Catholic partner, CCUSA, but we're very concerned about how that will, that work will be carried forward, but with the Catholic network being that it was the largest of all of the national agencies. The other cooperative agreement that USCCB pulled out of was the work that we did with unaccompanied kids, but social work. So basically the home studies and the post-release services, making sure that that the homes that they were going to were vetted and that we were in those homes and following up with the kids once they were reunified, and that they also pulled the cooperative agreement. In my opinion, that program is now very close to having those social workers be complicit with what is happening, because ORR has been transformed into more of an enforcement agency. I'm editorializing. I'm allowed to do that since I'm sitting up here. But that is my take. Is that when you start to have social workers whose mission it is to stay in the best interest of those kids and those families, and you pervert that, you run the risk of just, So I agree with that one also. I think you should have pulled out. But all the other agencies are still doing it, so it's really problematic. Margaret is the attorney of the two of us, but I'll also just mention we lost our immigrant court help desk, which was a very successful program to help the courts run more efficiently. To judges, that they could point to Catholic Charities workers there at 26 Federal and say, you seem lost, you don't know which way is up, go check with Catholic Charities people, and they're going to give you an orientation about what comes first, second, and third. And so that is a true loss, not just for us and our programming and our staff, but for these systems. It was a good program. And the instability in our unaccompanied minors legal program has also been, off the charts. Luckily for the city, kind of coming in with some critical resources, but again, this is a lot of instability, and kind of one thing goes away, and maybe some more funding comes, but will it continue? And that's kind of the way what we're seeing. So I'll try to close, but We've seen extraordinary resilience. We are trying to put one foot in front of the other and keep our chin up. But it is, I think what we really could use, just speaking for nonprofits in this space, is multi-year sustained funding, even if it's less funding that you might get, like 1 year a balloon of funding and the next year nothing, or kind of the unpredictability makes it so challenging. That it's hard to plan. It's hard to plan for continuity. It's hard to plan for staffing, and it's hard to build anything because you're not sure if it's going to still be there in another 6 months or 9 months or 12 months. Or trying to work and see what the impact of HR1 is going to be, of all the losses of benefits to people who formerly were eligible for like SNAP and Medicaid, so we're really, really concerned about that. I think it was very serendipitous. I over the weekend, I got a text from a former client. He's from Nigeria, and he actually attended the CMS Gala in 17 rather. And he texts me every once in a while, Happy Thanksgiving, Happy New Year, Happy Mother's, like 2 or 3 times a year.
You can schedule messages to send later in the messaging.
Okay, Bill. So he texted me, and he just was like, I thank Catholic Charities, and I thank you for the advice, and it was like really out of the blue. And I looked back at our thread, right, like through all of the other previous gifts of like Thanksgiving kind of nice things that he wrote, and I just thought it was so funny that I was just thinking about him and talking about him because we were going to the CMS Gala, and he's from Nigeria. His name is Wahab. He won Asylum pro se in 2017. He was detained in Elizabeth Detention Center. And one of the things I was commenting on about his story that we helped him do was that he had a criminal record as a result of his detention in Elizabeth, even though he had no real criminal record. But that prevented him from getting a job as a security guard. So we paid for his security guard training, and then we had to help him clean up that error on his record. So he obviously was very grateful for that. But, for us, it's just part of what we do. He became a citizen in 2023. He still didn't reunify with his wife or kids because I guess he missed that 2-year window that he could have done that as an asylee. But he is applying for them. In the meantime, he graduated from Bronx Community College, where he studied computer information systems. And he thinks that his family will be able to come next year. So I gave him, I don't want to tear up, but I probably will. I'll just explain to him the advice that he thanked me for, which is the same advice that I give to everybody that we talk to, which I think it usually sounds canned, but it's really sincere, which is step by step. We have to do it step by step. So.
If you're all right with, maybe we'll take questions from the.
Fine.
Okay.
I cry all the time.
So I think we're just about at time, but I do want to take maybe 2 questions from the audience.
We do have a virtual question.
A virtual question, lovely.
The question is, with the current administration, do you think the Department of Justice program for non-attorneys to provide services will be curtailed?
I just want to say, shh. I actually, it's not a line item on the budget. That's all I can say. No, they can't defund it. No, I mean,
Sorry, Robert.
There you go.
It's a powerful program.
Yeah.
Hi, everyone. Amy Gottlieb from American Friends Service Committee. Thank you so much for the work you're doing, and this whole day has been really thought-provoking. I'm really glad I pushed myself to be here. I have a little bit of a comment, less so a question, but I'm also curious to hear your reaction. I've heard a lot today, sort of defense of people who don't have criminal records. And as somebody who cares a lot about all people in detention, I want to really encourage all of us to be very careful with our language. We represent AFSC, our legal director is here. We represent many people who've had contact with the criminal legal system. And I think the more that we set up that good immigrant, bad immigrant distinction, we're setting ourselves up for even more problems than we already have. And I think it's become so entrenched in this latest iteration of what we're facing that more and more of us are finding it like important to say that, right? Like I get why people want to say it, but I just really, when I hear it, I get tense, and I just want to sort of put out there into this space that when we sort of disparage somebody who has a criminal conviction, we're actually causing harm to that person. And, you know, we all know many people who've lived in this country for many, many years who've had some kind of contact with the criminal legal system, whether, you know, I mean, we don't define people by their single act. So I just want to put that into the space, and with a lot of care and gratitude for all the work and everything that you've all shared.
Yeah, thank you.
thank you. And that's why I think the Catholic social teaching is so powerful. That's so powerful, because we use that language all the time, and I think it's important for us to always use it. So thank you for that. I really appreciate it.
Yeah, I appreciate you bringing that up too, and especially after Lake and Riley, right? I mean, like, what we define as criminal now is like unrecognizable.
All right, I think time for one more. Marciana?
Thank you. My name is Marciana Popescu, and I am a professor at Fordham University, also the co-director of her Migrant Hub. And I worked with Kelly for quite a while. Thank you, Kelly. I cried too many times. But I have one question. Like, we heard so much of what is discouraging and all the changes and all the uphill battles. And from my position as a university professor, a question is, how can universities enter or be more active in that space, and what can we do to support this uphill battle and work in partnership with all of you to really see some changes, starting with the social work students that we prepare on the ground. They should not, take a side that disfavors their clients. So I'm thinking of things that I think we can do, but I want to hear from you. What do you think we can do to support your work?
I would give you one idea. Go out into your community and with your students that want to, voluntarily, professors, and have a walk or a vigil to support immigrants around your 2 campuses would be lovely. But I think that's something that universities could do.
And I was just going to, I live right outside Washington DC, so all these groups are coming together, faith-based and otherwise, to accompany migrants, to take kids to school, to go shopping. I mean, really basic things that are really important because community members, our immigrant brothers and sisters are afraid to go out, so they're really powerful. They have a whole list of things they're doing, so if your students can, research that, there's a real need. So thank you so much.
All right. Well, I think that question actually transitions us nicely into the next panel. Before that, we will take one last very quick 5 minutes, real 5 minutes, not 6, 7, 10, 5-minute break. But before we do so, please join me in thanking Bill, Anna, Thea, and Kelly.